We are going to discuss about the types of delegated legislation, meaning and concept. The system of delegated legislation has developed gradually and historically without any fixed or systematic plan. The extent and limits of delegation have often been determined by practical necessity, convenience, and expediency rather than by any uniform principle. Delegated legislation may therefore be classified into different types according to the extent of legislative power delegated to the subordinate authority. There are generally four types of delegated legislation: normal type, exceptional type, Henry III clause type, and delegated legislation excluding judicial control. Normal type of delegated legislation. The normal type represents the ordinary and acceptable form of delegated legislation. In this type, Parliament clearly defines the limits within which the delegated authority may exercise its powers. The normal type has two distinguishing characteristics. Positive characteristic. The positive characteristic is that the limits of the delegated power are clearly defined by the enabling act. These limits are sufficiently clear to be known to the parliament, the executive, and the public, and they can be enforced by the judiciary. Thus, the subordinate authority is required to act within the boundaries established by the parent legislation. Negative characteristic. The negative characteristic is that the delegated power does not ordinarily include authority to legislate on matters of fundamental principle, to impose taxation, to amend the act by which the power is delegated, or to amend other acts of parliament. A good example of the normal type of delegated legislation is found in the Road Traffic Act 1930, under which detailed matters were entrusted to the subordinate authorities while the essential legislative principles remained with Parliament. Exceptional type of delegated legislation. The exceptional type goes beyond the ordinary limits of delegated legislation. In such cases, Parliament confers unusually wide powers upon the executive or another subordinate authority. These exceptional instances may be classified as follows: power to legislate on matters of principle. In certain cases, the delegated authority is given power to legislate even on matters of principle, and in some circumstances to impose taxation or duties. This represents an exceptional departure from the normal practice under which matters of fundamental policy are determined by Parliament. Power to amend acts of Parliament. In some cases, subordinate authorities are given power to amend acts of Parliament, including the parent act under which the delegated power has been granted, or even other acts. Such powers are exceptional because the ordinary rule is that a subordinate authority should not possess the power to alter primary legislation. Excessively wide discretion. Sometimes Parliament gives a minister or other authority such a wide discretionary power that it becomes difficult to determine the precise limits intended by Parliament. Such broad delegation may create difficulties concerning accountability and effective control over the exercise of delegated power. Illustration of exceptional delegation. Poor Law Acts 1930. Section 156 of the Poor Law Acts 1930 provided that the Minister of Health, with extensive power to make rules, orders, and regulations for carrying out the purposes of the legislation. The provision illustrates an exceptional delegation because the executive was given considerable discretion in dealing with matters relating to the administration and management of the poor. Gold Standard Act 1931. Under the Gold Standard Act 1931, the Treasury was authorized to make rules relating to matters concerning the exchange and operation of the gold standard. This illustrates the delegation of substantial regulatory powers to the executive. Import Duties Act 1932. The Import Duties Act 1932 authorized the Treasury to vary the classes of goods subject to duties and the rates of duty applicable to them. This illustrates an exceptional form of delegation because the executive was given considerable power to alter important matters relating to taxation and import duties. Henry VIII Clause type. The Henry VIII Clause is a form of delegated legislation under which the executive is given power to modify, amend, or repeal provisions of an act of parliament by means of subordinate legislation. It is named after King Henry VIII, who was historically associated with the use of extensive delegated powers. Nature of the power. Normally, an act of parliament can be amended or repealed only by parliament itself. Under a Henry VIII clause, however, the executive is authorized to make changes to primary legislation through delegated legislation. Because this gives considerable power to the executive, Henry VIII clauses are regarded as an exceptional and controversial form of delegated legislation. Delegated legislation excluding judicial control. Another exceptional form of delegated legislation arises where an enabling act attempts to exclude or restrict judicial review of the exercise of delegated powers. The purpose of such a provision is to prevent courts from examining whether the subordinate authority has properly exercised the power delegated to it. Significance. The exclusion of judicial control is constitutionally significant because courts ordinarily supervise subordinate authorities to ensure that they do not exceed the powers granted by Parliament. Therefore, provisions attempting to exclude judicial control are viewed with caution, particularly where they seek to prevent courts from examining illegality, excess of jurisdiction, or abuse of power. Conclusion. Delegated legislation may be classified into normal, exceptional, Henry VIII clause, and delegated legislation excluding judicial control. The normal type operates within clearly defined limits, whereas exceptional type gives usually wide powers to subordinate authorities. The Henry VIII clause permits the executive to modify or repeal provisions of primary legislation, while provisions excluding judicial control seek to restrict the supervisory jurisdiction of courts. Although delegated legislation is necessary for modern administration, excessive delegation must be controlled to preserve parliamentary supremacy, the rule of law, judicial review, and protection against arbitrary exercise of governmental power.